Okay, good morning.
Morning.
Okay, we're here for a session of oral arguments, the 5th District Court of Appeal. Our first case this morning is Mark Fugler versus State, 19-2710. I'm Judge Evander. The other members of the panel are Judge Edwards and Judge Harris. You'll each have 20 minutes aside for oral argument. There is a clock on the screen that should help you as far as keeping time, but if the appellant wants assistance on reserving time for rebuttal, just let me know how much time you wish to reserve. Also, I want to remind you that these arguments are being live streamed so that the public has an opportunity to view them. With that, Mr. Foreman, you may proceed.
Thank you. Good morning, and may it please the court. My name is Jason Foreman, and I represent the appellant, Mark Fugler. I would like to reserve 5 minutes for rebuttal, please.
Okay.
And as the court knows, the appellant was convicted of numerous lewd and obscenity offenses involving a minor. And just like most of these type of cases, it involves a substantial amount of child hearsay evidence. So I'd like to first address the issue involving the child hearsay evidence, which was pretty substantial in this case. We had the CPT interview, we had the CPT interviewer, Ms. Plummer, and we had the mother's testimony as well. Now, the child hearsay evidence in this case cannot be deemed reliable because the trial court's entire analytical process was flawed. And initially, the court failed to articulate its factual findings as required by the statute. The court simply said that the child's testimony was age appropriate and that there was no coaching or coercion or threats or anything of that nature. This falls miserably short of the requirements of the statute and the case law that requires more than just the boilerplate language. But perhaps more importantly, as set forth in argument 1B of my brief, the court specifically said, I'm not considering any of the inconsistencies at all in my determination of whether or not the evidence was reliable. This in and of itself requires a determination that the evidence was not reliable or cannot be deemed reliable, because the very essence of this determination.
About preservation here. It seems to me the judge's comments was arguably ambiguous, that he was indicating that, there was some inconsistency, some impeachment on that, but that he still found it reliable and that the defense counsel could bring that out in front of the jury. It also strikes me reading this that the judge obviously could have made more factual findings if asked to do so. Why shouldn't we require defense counsel to say, Judge, I think your facts are insufficient, and have the judge have an opportunity to either correct it or not correct it?
Your Honor, admittedly, most, if not all of the district courts have said that an additional objection is required. But the Hopkins case, which is what controls this case, specifically says, and that's the 1994 case from the Florida Supreme Court, specifically says that when you object to the reliability of the evidence, inherent in that objection is the fact that is whether or not the evidence was actually articulated, whether the findings were articulated properly by the court. And the leading
case came out about 3 months before Townsend, and Townsend seems to say, an objection is required. And I agree that, when they say it, they don't mention Hopkins, but it is certainly the more recent of the two Supreme Court cases dealing with the issue.
It is, Your Honor, but it doesn't address the issue squarely like Hopkins does. And the Elwell case from the second DCA in 2007, which all the courts rely on, in the concurring opinion, one of the judges actually says Hopkins is controlling, there's no objection required, but under the facts and circumstances of this case, it was harmless. Now, I also cited in my reply brief a case called Coleman, which is from the First District Court of Appeal. Now, admittedly, in that case, the majority said that a further objection is required, but the dissent does a really nice job explaining why Hopkins is still good law. They talk about
in that case, the concurrent opinion, the judge mentioned there had been a change in the statute on preservation that had come out after Townsend and Hopkins. What's your response to, I think it was, let's see, Judge Thomas. I think, what's your response to Judge Thomas's position on that?
Yes, Judge, in a concurrent, especially concurring opinion. Your Honor, all that statute did was codify the rules of preservation, and that's what it says in the Coleman dissent. And I'm asking the court to adopt the reasoning of the Coleman dissent, especially in light of the fact that the Elwell case, the one judge did find that Hopkins was still squarely on point. It's still controlled. It just was harmless error under the facts of that case. And I think in this case, it can never be harmless because of the court's expression that it did not consider the inconsistencies. And in my view, I don't believe that there's any ambiguity at all. The court recognized the inconsistencies. The court said, I'm not going to consider those. Those goes to impeachment, and you could do with the impeachment, but it doesn't go to my threshold reliability. Then what is the court's role if he's not going to consider the inconsistencies? Then basically the entire process is flawed. So all of the child hearsay evidence was improperly admitted. It can never be deemed reliable. And all that's left is the other evidence that was presented. And the bulk of the testimony and the bulk of the evidence was from the mother, which is child hearsay, was from the CPT interview, which is child hearsay, and from Ms. Plummer, who was a CPT interviewer. And additionally, the actual testimony itself was not reliable. The child waited 2 years to disclose it. She initially lied. It wasn't voluntary. These are factors that are highly relevant that must be considered, especially at the time of disclosure and the fact that she initially denied it. She initially said her younger brother was exposed to the appellant's penis, but it was actually her. So setting aside the preservation issue with the factual findings, the Townsend decision still says that that could be considered when determining whether or not fundamental error occurred. So even if the court finds somehow that Hopkins doesn't control, that an additional objection was required, this can still be considered whether or not fundamental error occurred. And of course, in ground two of my argument, where I packed everything in as much as I could in there, I believe that there's a lot of merit. Those arguments are meritorious. Argument two of my brief, I argued that a new trial is required due to the numerous amount of improper evidence that was admitted. I'm not saying that every single error was fundamental. I'm saying the cumulative effect of those rose to the level that it denied Mr. Fugler a fair trial. And the bulk of the argument deals with the CPT interviewer, Ms. Plummer. If you look at her testimony carefully, she didn't testify about what she did. All she testified to was about what she thought, and that's improper. She testified on direct examination on page 319 and 335 of the record that her job was to assess the allegations, assess sexual abuse. There's no doubt about that. Yet she tells the jury, I'm trained to look for signs of coaching. And then the prosecutor says, well, did you see any signs of coaching? She says, no. This is what she thought, not what she did. She says she's trained to look for details, whether the child's being consistent, whether they're descriptive. And she says, if not, then it would really jump out at me. So then she gives her opinion, what she thought. She says, well, the child in this case was very descriptive. She was very consistent. And, she was able to describe all of the allegations. And of course, this really came to a head when the prosecutor asked her to compare the child in this case to the other 700 or 800 other children she interviewed, and asked her, hey, does this one stand out at all? And she tells what she thought, not what she did. This one stands out to me. The child was so detailed, so specific. She demonstrated everything clearly. She corrected me a few times. She was really detailed. She had a really detailed history. All of this is improper vouching. Now, the prosecutor was clever enough not to just flat out ask her, do you believe the child? But there's no doubt that was the message conveyed to the jury, that Ms. Plummer believed the child, that she was credible. And it wasn't only Ms. Plummer. She did present some testimony regarding peer review, regarding other doctors and experts in her office. Now, her first statement might not have been egregious regarding the peer review. She just kind of mentioned it in passing. Yes, we have some other people in our office. They also review things. But then the prosecutor made it a point and specifically asked to highlight this. And it's on page 35 of my brief. He says, so truly, when you're saying child protection team, it's not just one person interviewing a child and creating a report or findings or things of that nature. It's the whole group. And the key there is when they talk about creating a report or findings, because the message is clear to the jury that she believed the child. If they all take part of the creating a report or findings, then they obviously believe that the child's credible as well. Then the prosecutor continues to use Ms. Plummer as basically a conduit for all things inadmissible and starts asking her about her common experience for sex offenders, for perpetrators. Is it common for perpetrators to have positive interactions, to buy ice cream, to buy gifts? She's basically talking about grooming. And then she starts answering the question. Yes, of course. These are all improper. This goes way beyond her expertise as an interviewer, way beyond her. It's just highly improper. Then she starts talking about other child victims. That's improper as well. She says, well, is it common in your several hundred interviews of children for these children to have positive feelings about the individuals who sexually abuse them? That's basically saying that's a common trait of all of the children who are sexually abused. This is, again, highly improper. And of course, the prosecutor laid all these out right before the end of his direct examination. But what's really, basically what really brought this all together was the prosecutor's question to the defense expert. The defense expert made it a point to explain to the jury that none of the pornography nor Angry Birds were played on the specific dates alleged. And the state expert, who was a law enforcement officer, agreed. So the prosecutor asks, for the first time ever, brings out the statement, asked the expert, how do you reconcile your findings with the fact that Mr. Fugler admitted to playing Angry Birds? The prosecutor knew that none of the defendant's testimony was going to come out, yet he elicited this. And I didn't realize this at the time, but on page 149 of the record and 151, the state actually objected to defense counsel's questions trying to elicit any testimony from the defendant. And in fact, it was actually a motion in limine made by the state attorney seeking to prohibit defense counsel from asking any questions. So this clearly was a question in bad faith, knowing that they weren't going to present any evidence, because the prosecutor not only objected, but the prosecutor agreed, we're not going to present any of this testimony. We're not going to present any of this evidence. So then all of a sudden, springing on the defense expert that, hey, what about Mr. Fugler, what he said about Angry Birds?
When you say we're not going to present any evidence, are you referring to the defendant's statement to law enforcement?
Correct. And that's on page 149 and 151 of the record.
So we have a situation where during his statement, he did say that he had played Angry Birds with a child, but then the state moved in limine to have any of the statement come out?
Any self-serving statements, yes. But during that discussion, yes. But during the discussion, they specifically said, we're not going to elicit any of this testimony. We're not going to publish any of this to the jury. And again, that's on page 149, 151 of the record. So this question was clearly in bad faith. And as far as the Angry Birds, it's a little bit ambiguous whether he said how often he did it. On page 876 and 77 of the record, he says it was one time. On page 889, 890, he says on her tablet, and page 908 to 09, it says on his laptop. So there's an admission that they played. It's a little ambiguous whether it's more than once. But again, this statement was so powerful that it basically made the defense expert look a little bit foolish. Then, of course, the state law enforcement officer, the expert, talks about the private browser, says that a private browser is basically designed so that husbands could look at pornography and hide it from their wives. And of course, because it was used in this case, that's a tie-in basically, hey, he must have done it because private browser was used. And then, of course, there's the improper comments and closing argument, where the prosecutor is trying to invoke a hostile response against the defendant, where they talk about, hey, this is a defendant who breached a family trust, who took advantage of them. And this court in Brinson, as set forth in my reply brief, said that's an improper argument. You're trying to invoke a hostile negative response against the defendant. Then there's also comments, why would she lie? There's no evidence that she would make this up. And I would submit to the court that the Bell case, which is the Florida Supreme Court case, considers that an impermissible shifting of the burden. And I see that my time is up, so I'll reserve the remainder time for my rebuttal.
All right, thank you. Ms. Davenport.
May it please the court, my name is Chris Davenport and I represent the state of Florida. Starting with the factual findings, I think the case law is clear that you have to preserve that.
Let me ask you this, do you think the findings were sufficient?
I think they were not fabulous, but I think they were sufficient. The courts that have found them insufficient, it tends to be a real boilerplate. You know, I looked at this under these factors and it meets it. This one is not extensive, but it does say, here's why I think these were reliable. Her language was age appropriate. There's no evidence that this is a situation where there was a motive to lie or coaching or anything like that. And those are all important factors in evaluating whether or not this type of hearsay can come in.
Should the analysis be done as to each statement?
Yes, you know, I think that's what the case law says, and he did it here. He mentioned the two statements. You know, I considered the mom's testimony and the CPT testimony, and I find they were age appropriate, and there was no coaching, and there was no motive to fabricate, and those other factors he addressed. So I think he did find it as to each statement. And again, you know, we've certainly seen better factual findings. He could have made better factual findings if there had been an objection lodged below, and there was ample opportunity to do that. You can't just sit on your hands and then spring it on appeal and get a new trial. That's not how this works. It's not a game. As far as, you know, whether or not there was sufficient evidence that hearsay can come in, the circumstances of the disclosure, the child had become withdrawn 6 months before, she'd started dressing differently, more like a tomboy, she wasn't affectionate. The mom wanted to see her diary and she wouldn't let her, which was unusual. This was a spontaneous disclosure. This wasn't, you know, mom saying, gee, has anybody been touching you or anything like that. Yes, the child tried to pin it on her brother and say that this happened to him. That's a lot different from a lie of some neighbor showed me his penis. She lied about who it happened to, not who did it. She always maintained consistently exactly who did it. And that's, you know, the lie, it happened to somebody else. That's pretty similar to, you know, I have a friend and let's talk about this, putting it on someone else to try and save embarrassment.
On the preservation issue, let me ask you, what would your response be to Judge Maycar's dissenting opinion in Coleman?
My response is, number one, it's a dissenting opinion. And number two, he's wrong. When you look at the Elwell opinion out of the second DCA, which seems to be where all the other courts are following, first of all, that was written by then Judge Kennedy, who's now in the Florida Supreme Court. And he explained why Hopkins was not controlling. And he explained why you have to have a specific objection. The whole point of this is to allow the court to correct it instead of having to go back and do another trial if there's a way for them to correct it. And there certainly is an easy way for them to correct it. If an objection is lodged to this, he could have written a better order. Or maybe he couldn't have, but you have to raise an objection to give the judge a chance to fix it. You can't just wait. So I would submit that Judge Maycar is wrong and Judge Kennedy's opinion is correct in Elwell, and the majority opinion is correct in Coleman. It all follows Townsend, which came out after Hopkins and said this is not fundamental error. In other words, it has to be preserved below, and it was not preserved here. And again, there is sufficient evidence to support the court's conclusion that this hearsay was admissible. Yes, there's inconsistencies. Every child is inconsistent on certain things. I mean, if you've seen a lot of these cases, they never tell a perfect story. They're little kids. That's just the nature of their testimony. As
Let
far
me
as
ask you about the cross-examination of the defense expert. Now, certainly there was evidence that, you know, that the prosecutor had, that the defendant admitted he had played Angry Birds with the child. But did the state, and I don't recall it being in the briefs, Mr. Foreman mentioned he just found it, but do you recall whether the state had an argument in motion liminis, whether the prosecutor had stated they did not intend to introduce any part of that statement?
I believe the motion in limine said that this was a self-serving statement and asked the court to preclude the defense from referring to it because self-serving statements can come in. Now, obviously, the Angry Birds portion of that is not self-serving. It's a tad incriminating. But let me also reiterate.
Right, I agree with that. But did the
Birds.
prosecutor, do you know, since it just got brought up today, did the prosecutor also state that the state did not intend to bring any of that statement into evidence?
Yes, the state did not intend to bring that into evidence. I think if they brought in the Angry Birds and introduced that portion of his statement, that the rest of his statement could have come into. But let me reiterate, this is an expert witness, and you can ask an expert witness about the basis for his opinions. One of his opinions was there's no Angry Birds in the computer. Now that conflicted with the opinion of the state's expert who said he did see a reference to it, but he wasn't looking for it.
What was the defense expert asked what materials he had reviewed in preparation of his testimony?
I think that's what this question was.
Well, that's a different question. I mean, he could have said, I looked at the computer and I did nothing else. Or he could have said, I looked at the computer, I looked at the discovery that the state had provided to defense counsel, which was also provided to me. I mean, was there any question along those lines preceding this particular question?
I don't believe there was, no, Your Honor. So in that sense, perhaps the foundation for this question was a little lacking. Again, no objection was raised below. So we're talking about a fundamental error standard. If there was a foundation problem, they should have raised it below. It's proper to ask if he's aware of all the evidence when he makes his opinion. It's not like asking a lay witness about something like this. This was an expert witness, and it's acceptable to ask what the basis of their opinion is. And this is one of the things that he should have considered if he was going to render an opinion about Angry Birds. Again, let me reiterate, this is a fundamental error. There was no objection below. Excuse me. The defendant was not charged with playing Angry Birds with the victim. He was charged with molesting the victim. So this was a bit of a side issue anyways. It further corroborated her testimony because she explained it in the context of they would watch the videos and then they'd play Angry Birds. Maybe that's how he got her to hang out with the computer. So it certainly corroborates the victim's testimony, but Angry Birds is a bit of a side issue here. So it certainly doesn't raise the fundamental error analysis. And again, it's proper to ask an expert what he based his opinions on. Again, maybe the foundation was not great, but there was no objection lodged on that ground below either. I would also note that the jury was specifically told what the attorneys say is an evidence. And the defense expert made it clear that the only way he heard this was from the prosecutor. He didn't see anything that said that. So if the jury followed their instructions, and we assume that they do, they didn't consider that evidence anyways. As far as the cross-examination, the examination of the child protection team expert, or quasi-expert, I believe is how the defendant refers to her in his brief. It's proper, this court has said, for experts, for experienced witnesses like this to explain to the jury how to evaluate the veracity of the witness. That when you have a child victim, things that seem like they are unusual but really aren't under experience, that it's proper to tell juries about that.
I recognize there's no objection to this particular question, but what about the question, could you compare the child to the 700 or so other children that you've interviewed? Do you think that was a proper question or a proper response?
Well, the actual question was, did anything about this interview stand out? And you've done 800 of them. Was there anything about this that stood out? I don't really see the relevance of that. I think if an objection had been lodged, it would have been sustained. But we're talking about one question out of a very lengthy trial. It's not like this was emphasized in the state's closing argument or they made a big deal about it. It was one question. I would not ask that question. Probably should have sustained an objection if there had been one raised. Is that question fundamental error? I would argue that it's not. When you look at the evidence in this case, there's extensive testimony from the victim. She explained what masturbation looks like. Her testimony was confirmed by the physical evidence. She described the pink lotion bottle that he used to masturbate. They found a pink lotion bottle. She described that he put the laptop on a laptop holder so it could be on the couch with them. They found his semen on that laptop holder. She mentioned what website he went to. They found numerous references to that website. And then we have a diary, which the pages of that are included on the record on appeal. When you look at that diary, that is a child who's been exposed to things that 5-year-olds aren't normally exposed to. It's certainly a lot of physical evidence here that supports her testimony. There's always inconsistencies, but this kid was very consistent about what happened to her and who did it. It was the defendant. He masturbated repeatedly. Here's what it looked like. Here's what happened at the end. And I saw these videos. I drew them in my diary. Here's what happened on those videos. And coincidentally, that's the website he went to on his laptop. So this is not a case where any little error where it's he said, she said. There's a lot of evidence in this case. So was that question inappropriate? Possibly. Was it fundamental error? We submit that it's not. He raises a lot of issues in this case, and you could sit and nitpick what questions were asked and what closing argument statements were made. We would submit that most of those were completely proper. If there was error, it certainly didn't rise to the level of fundamental error, especially in light of the other evidence in this case. If the court has no other questions, we would ask.
Yeah, I do, Ms. Davenport, if you don't mind, because Mr. Foreman didn't get there yet, but maybe in his rebuttal he will. Talk about, if you can, the evidence that was presented specifically on counts 4, 5, and 6, the sufficiency of the evidence to sustain those three or all three of those convictions.
Let's see here, 4, 5, and 6. That was the lewd and lascivious conduct.
Correct.
That was where that was alleged where the victim was asked to touch his penis or the defendant took off the victim's pants.
Which of those did she testify to during the trial?
During the trial, she testified that the defendant tried to see her privates and she did not like that. She talked about
that's an attempt, right? Would that by itself qualify?
No, not with, if that's all we had, that would probably not qualify. She
Okay,
talked
what did you
about,
have?
in the testimony, in the trial, she talked about the bear claw game where he would pull her pants down. And she talked about how he was inappropriate every single time that they were together. But then you look at the child protection team interview. She talked about how he tried to touch her private, and she talked about 2 incidents where he removed her pants. One in the context of they were sitting on the couch watching these porno videos. The other one was where he was dancing naked and he had taken off her pants before that. So she did describe 2 different incidents in there. So we have the bear claw game, we have the dancing, and we have the just watching porn where he took off his pants, her pants. So those were 3 separate incidents, and we would submit that that was sufficient. The Florida Supreme Court has made it clear that hearsay, child hearsay is substantive evidence. It can be enough in itself to support a conviction as long as it's not, refuted at trial or where the child says that didn't happen at trial.
Was there a specific motion for judgment of acquittal on those counts?
I'm sorry, could you repeat that?
Was there a specific ground set forth in a motion for judgment of acquittal as to those 3 counts?
There was not. That was not argued below. Again, this was a claim that was not preserved. And we would submit that even if it had been argued below, it wasn't it wouldn't have been granted because there was sufficient testimony to allow the jury to determine whether or not there were 3 separate incidents of lewd conduct, and their verdict is supported by the record.
Any other questions from the panel?
Right, thank you. We would ask you to affirm.
All right, thank you, Ms. Davenport. Mr. Foreman, rebuttal.
Yes, thank you, Your Honor. First, I'd like to address the characterization of the Angry Birds evidence as basically de minimis. I mean, it was very important in this case because the evidence presented was that every time that Angry Birds was played, pornography was shown as well. So it was used to go hand in hand. If Angry Birds wasn't played every time, pornography wasn't viewed every time. And the defense expert even had a big chart presented at trial that listed all the different times Angry Birds were played with none of the dates actually on the dates alleged in the information. As far as the statement made by the prosecutor to the judge indicating that they were not going to elicit any testimony from the defendant, again, on the page 149, the prosecutor says, I've indicated that the state does not plan on calling or playing or publishing to the jury the defendant's interview. So it'd be the state's position that any questions regarding the content of the interview are self-serving hearsay. So clearly the prosecutor acted in bad faith by asking that question, knowing that they were not going to elicit any testimony and having basically had committed to it and had defense counsels prohibited from doing so. Now, as far as the semen sample that was found, I mean,
Let me ask you this.
Yes, sir.
I know the deposition, there's no deposition of the defense expert in the file, in the record, I don't believe. Was there an indication in the record before our court as to whether a deposition of the defense expert had been taken by the state before trial?
There is a deposition, yes, Judge.
Okay.
I believe it's in the record as well.
Okay, if it is in the record, do you know if the expert was asked about what he had done to prepare for trial?
I don't know, Judge, but the question is, he clearly wasn't asked, he clearly did not know that Angry Birds was, that the defendant admitted to Angry Birds. So,
but if he had been asked, for instance, what materials you had used, what had you done to prepare for your trial? If he had indicated that he had reviewed discovery, that would be a question asked in good faith if he had said something in his deposition about that, wouldn't it?
well, I respectfully disagree because once the prosecutor said, hey, listen, Judge, we're not going to get into any of this. He shouldn't be getting into it. We're not going to get into it. And then they get into it, that breaches the agreement. I mean, can we take a prosecutor's word on its face value that they're not going to ask questions?
Yeah, but would that question though go to his preparation for his testimony? A question that could be asked of an expert as to what they did to prepare for trial.
Yes, but it talks about data. And that's what even the rule says. It talks about facts or data.
That would be data, right?
Not when he's analyzing a computer, then it wouldn't be data.
It's not uncommon for experts to say, I reviewed all the depositions in this case. I reviewed the affidavits that have been filed, and based on all that and my calculations, I conclude this or that. I mean, it's not uncommon for experts to review deposition testimony given in the case as part of their expert testimony.
That's correct, Judge. It's not uncommon. But
Okay.
based on his answer here, he had no idea. It was totally sprung on him. And what's interesting is the prosecutor in her closing says, you know what? You're right. There was no evidence that there was a statement made or there wasn't a statement made. It was interesting how she characterized that. She didn't just flat out say, listen, you can't consider this evidence. There was no testimony of it at trial. She said it in a way as if there was evidence, but you didn't hear about it. And that was under the prosecutor's rebuttal argument. As far as the other evidence that was presented, I mean, the child's testimony at trial was more vague, more ambiguous. It wasn't as clear cut as in the child hearsay testimony. That was where the bulk of this evidence came from, so child hearsay evidence. So looking at the entire record, looking at the entire trial, we have improper opinion testimony by the CPT interviewer, testimony about perpetrators, improper closing argument. We have child hearsay evidence that cannot be deemed reliable because the process was flawed. We have inadequate findings. You stack these on top of each other and you get cumulative error. He's denied of his right to a fair trial. And I see that my time is up, so I'm asking the court to reverse on every count and discharge on the appropriate counts that are set forth in grounds 3 and 4 of my brief.
Oh, thank you both. Well-argued case, and we'll be in recess.
Thank you.